of the finest, we have one of the finest Bill of Rights in any constitution in the states. I would put it up against anything. It's far more extensive and inclusive than the Bill of Rights attached to the U.S. Constitution. And it's, we have wonderful rights, and those rights are all inviolate, except for those of us that they're not. We have such discrimination in this state. I'm here to speak about the vexatious litigant statute, which I consider to be the most evil, vile, unconstitutional statute ever put on a book. It is a discrimination against one set of people that are, those are non-bar card members, also known as pro se litigants. That says that if a pro se litigant sues for cases within 7 years and has an adverse decision, that they can be struck from, they can be given the label of vexatious litigant, and their life in a court is over. It originally came from California, and it said any vexatious litigant, any pro se litigant, they call them impropriety persona, who sues the same set of defendants 5 times for the same cause can be labeled a vexatious litigant. In California, when they did that, they banned them from the courts for 5 years or so. In Texas, they took all that language out, and Senator Royce West, a couple of years ago, made it where there is nothing, but you go to court, it's a vexatious litigant, it's a pro se litigant, you're going to lose your rights forever. And it is a life sentence, it's not appealable, it comes from a district court level, and I've seen such atrocities done with that. My son's name was Rep. Peace. He had the finest legal mind of any person I've ever met in my life. He loved the law. He studied it. He was named how an attorney uses the vexatious litigant statute is, if they don't have an argument against the person before them, they say, oh, they make a vexatious litigant charge. Now, they never get to the merits of the case because we're only dealing with vexatious litigant. They have to post a bond, blah, blah, blah. They didn't even give him an opportunity to post a bond. So he was named for trying to sue a company that had stolen his car out of his driveway. He was named a vexatious litigant. And when it finally dawned on him what that really meant, it means you're without law. This Constitution, or Section 20 of Article 1, says that no citizen can be outlawed. You want to bet? He's not here to speak for himself because he is dead. He was given that vexatious litigant label. I can't tell you how much it bothered him. The day that he took his extensive law library and made a bonfire and burned every one of those books, it broke my heart. But he said, I have no law. I'm a dead man walking. I have no law. No law protected him, and he didn't have any access to the law. And that's how the vexatious litigants feel. And again, no due process. 19 of this book says you can't lose a right, you can't be disfranchised. None of those things can happen to you without due process of law. I have a client that got a vexatious litigant with one case against him. I saw another one he'd been stolen from. The attorney the attorney didn't have a prayer, the opposing attorney didn't have a chance at all. He said Kevin was a vexatious litigant. Kevin had owned 8 houses before 2008. And he fought for every one of those houses. But it's not enough to consider the suit. Anybody would appeal, so you got the suit, the appeal, and then the third appeal. And that's 3 cases to them, not 1. It has to go. It's people's lives. and it has to go.
Time's up, thank you. Any questions for the witness, or witness, the delegate?
Trustee, 27, beg your pardon. Have you written any legislation to repeal this, or do you have anything to share with us?
I haven't written any legislation to repeal it. You have no idea how much time I've spent at the state capitol. I live in Austin. I've never, no matter how many times I've made appointments, no matter how many times I've been down there, no matter how I've tried, just a lady on the street. I'm not hurt.
So, there is also,
Vexation litigation, yes I am.
litigation.
Yes ma'am.
You applied it as a platform.
Okay.
We certainly can consider that, but just a simple line, you take that to the platform committee with your story.
Well, I believe so. Is that count me out on the platform? Okay, 76, and these are the king's courts. And we have a long train of abuses. But thank you so much for that suggestion.
Questions? Thank you so much. The committee would call Mr. Jeremy Blake.
As he's coming up, I would remind the committee, we've still got a fairly lengthy list of delegates that want to testify, and without revisiting the 5-minute rule, which of course y'all can do at any point, I would caution you to keep very brief and try to word them so that they are very short, if not yes/no types of answers. And if you have to put the details, that would be better at this point if you took that offline after they've finished their testimony. Thank you.
Jeremy Baker, Gaines County, SD 31. The issue that I'm speaking on is the legislative priorities. We support allowing this law either as a lawyer, as a paralegal, or regardless of where he or she received their law education from, as long as the criminal and ethical background checks are met, and with legal is not a member of the bar group. I've been doing a lot of research on Mr. Abraham Lincoln. Abraham Lincoln was a self-taught lawyer. He studied law for a year. He had been involved in quite a few different cases. He had won 37 murder cases. He became pretty popular. He was able to run for president and win. And then afterwards, he started this Republican. And we're seeing that we have disenfranchised our own founder of Article 1, Section 19 of the Texas State Constitution. What I have experienced in my own regards is I have won a lot of cases. I've won 140 helping people assist themselves, kind of teaching them what their Constitution says and what their rights are. And then I would understand what their position is and how to move forward. Because I wasn't able to speak, sometimes things would last for like 6 or 8 months of misunderstanding and had my first day in court. It's just your strategy and your approach to it. My aspectizing our own founder of our party, I mean, this is kind of ridiculous. If you notice that some of Abraham Lincoln's wins, he wasn't winning on the rule of law. He was winning on the common sense mentality. I mean, like, there's a murder case that's involved with Abraham Lincoln, and what he's dealing with is a situation where the prosecutor is already deemed his client 100% guilty. Now, granted, Abraham Lincoln is the mom and pop's lawyer. He doesn't have a bar card. He's basically helping the younger. He's helping a family that's in need. The prosecutor already had their son basically locked in to a guilty verdict. But when you had Abraham things that was going on, he realized there was some common sense that needed to be addressed here. Pulled out an act showing that they couldn't, that there wasn't a full moon on that night, so there's been supposed cause of death blow. They cut it open and it showed that they could never have caused a death blow. A lot of that stuff is not the law, it's just common sense evidence that needs to be presented to the jury. A lot of that stuff is pretty self-explanatory when you get down to the situation of you can see that this isn't going to kill somebody. You don't need a law for that. And then most of the time, we're finding that pro se litigants are coming in and they're not being treated as they're being disenfranchised just because they're representing themselves. If they come in as a bar member, you'll get promotions granted, you'll get all kinds of things. But if you come in as a pro se litigant, even though you're using the same rule that the lawyer is, they're creating a bias against you, and basically an adversarial position, which is kind of weird. But the aspect of it is if we're all going by the same rules, I don't see what the problem is with them going in and defending other people. Especially the person does have a right to choose whoever they want to represent them. I mean, that should be a God-given right. I just look at the aspect of there's so many people in family court, and so many people in criminal court, and so many people in civil court that need somebody that is, got some experience, that can be a paralegal, can help them draft, write paperwork and stuff like that. Could also speak on behalf of the motions. If they had that, you wouldn't see a lot of the complaints that we're seeing where fathers are getting ripped away. The attorney, I spent $200,000 on this attorney and I still lost. All these things that are coming to the table, we're seeing that there's a lot of corruption in the court, and it has to do with the fact that these people have got a monopoly on the court system, and because of the monopoly that's been put on the court system, it's made it so our freedom of speech, our right to speak, has been taken away. And I think that's a key issue, and I think that it should be addressed. Thank you.
Does the committee have any questions? Thank you so much.
Thank you. My name is Bradley Pierce. I'm a delegate from SD5, speaking on the abolition of abortion. Thank you all very much for the time you've given to be here and the work that you're doing. Very much appreciated. I'm the executive director of Abolished Abortion Texas. I'm an attorney. I'm particularly sensitive about that after the last speaker here. I'm a lifelong Texan, Republican, and I've been practicing law for the last 13 years. And like I assume everybody here, I love life and I hate abortion. Like I hope everybody here. So I want to talk about something that has come up in two different strategies that are being discussed here today. And that is something called the Texas Abolition Strategy, and something that we just call abolition at Abolished Abortion Texas. So what is abolition, or what we would call true abolition? Well, first of all, true abolition is about asserting what our party principles state, which is about protecting life from fertilization. That's what we state in our party principles. That's what abolition is about. Number two, abolition is about providing equal protection under the law to all preborn babies. No one should have a license to kill a single innocent child. Number three, abolition is about standing on the Constitution and sovereign independence. We see a lot of things in our state and our country under specific judgment. But I think what we're seeing in this country, we're seeing is abortion. And what is the answer to judgment? I yield for any questions.
Recognize Rich Dion.
Thank you, Rich Dion, SD5. Bradley, it's good to see you again.
You too.
Thank you for being here, and really appreciate the work that you do, because I think it is affecting the culture. You got to affect the culture, we also have to affect the lives. So I congratulate you for that and the people you work with.
Thank you.
I've got some questions and a little design here to try to highlight the important distinctions between what I'm going to call incrementalism and true abolition is what you call it. First of all, the last convention, and I pulled my Senate district.
One quick interruption.
Yeah.
We don't wanna prosecute the case at this
Exactly.
point, so keep everything short, please.
I will try to do that, and I've talked to Mr. Pierce beforehand, so we'll both keep it brief. We just want to kind of highlight these issues. I went back to my SD and asked how many of them would support, this is a conservative Republican Senate district, criminalizing the woman, which is, whether y'all are doing that or not, that is what it's going to look like to people. And 2% of the people in our Senate district, which is basically 2 people in about 130, so it's not even 2%. How do you respond to that?
I would say what Wes said, right, we're criminalizing conduct and not a person. It applies equally to everybody. Secondly, I would say that the bill is not, what we're advocating for is certainly not retroactive, right? Not anyone who's already had an abortion before the bill goes into effect would be subject to prosecution. Additionally, anyone who's had an abortion would have the same defenses that anybody else would have to homicide, to a charge of homicide. They'd have the defense of duress, right? Anyone forced into an abortion would not be prosecuted. They'd have the defense of mistake of fact. If they don't know what they're doing, then they would not be subject to prosecution. They would have all of these defenses. If it's a miscarriage or a mistake, or an accident, something like that, right? Then of course, that person would also not be subject to prosecution. So there's all these defenses that would already apply. And then the other way that I look at it is, someone brought up an example of, well, what about the 17-year-old who's taken by her mother and that sort of thing? Well, we don't write laws for specific cases. Now, we take specific cases into account, but we don't write laws for specific cases. We write laws to create a standard that does not discriminate, right? That applies equally to everybody. Then we have the justice system. We have law enforcement. We have prosecutors. We have juries. We have grand juries. We have judges, appellate courts, and so on and so on. And we have the governor who's even part of that, who can pardon or commute sentences. That is the realm in which we would then consider each case on a case-by-case basis and take all the mitigating factors into account and all the sympathetics, all of that into account in those situations. And the situation that was brought up, or the example, probably would never get prosecuted, right? But when we're writing law, we write law without any discrimination. We write law to apply equally to everybody, and that's what we're calling for. That if we're really saying that the life, in my wife's womb right now, actually twins, that life is just as valuable as our lives here, then the same law needs to protect that life.
You've knocked off 2 other questions, which is great. The incrementalism argument, I believe, will save lives. And I'm going to give you 2 examples. Constitutional carry, we started carrying back in 1992, I think, with Jerry Patterson's bill. And things have changed over time as we've taken, and now we're trying to get full constitutional carry. And we're on the verge of that, hopefully. Slavery in England ended with incremental legislation, starting and working its way in towards England to where they ended. Do you know of a single case where you've made major social perception changes with one law at one time?
Well, again, everything happens incrementally, right? Everything is one step at a time. So we're not disagreeing about things happening incrementally, but Wilberforce, his chief opponents were called gradualists, right? They were the ones who wanted slavery gradually. You can see this in the movie, right? Amazing Grace. Not that I'm saying movies are, I wish I had been less incremental or less gradual in the way we went about things. But again, that's a very different situation since there wasn't actually slavery on the shores of England, right? It was in the distant colonies. So that's an answer to, why it's different there than here, because it's a very different situation as well.
Right, so the last question, when you say ignore Roe, and it's on all the t-shirts, it's going to end up in court. Somebody's going to file a lawsuit, and your answer is Texas just doesn't show up in federal court on this.
That is an answer. Another answer, not to get too lawyery here, but is to file what's called a plea to the jurisdiction, where you're saying, I'm showing up, but I am not consenting to the jurisdiction of this court. And if I don't like the outcome, then I'm still going to, assert my own rights.
Right. So my specific question on that is, you get to that point, whatever legal tack you take to address the lawsuit,
Right.
You're gonna end up in federal court.
Correct.
And how do you think that's gonna go? Texas, do you think there's enough political support? Because you gotta have some support out there to take an idea. Everybody else lets you run off towards the battle, and they sit back and watch and think, that's not gonna work.
Right.
It's not gonna end well. So can you talk about that? That's one of the most significant issues in the differences between the two.
Right, and I'm going to be in agreement with you that, are we there today? Right, do we have that kind of support today where that could happen? No, we're not, as a culture, right? As a state, as a culture, we're not there. But how do we get there? How do we get there? I believe it's by people like this group here and this party leading the way. And by saying, this is what the standard should be. This is what justice is. This is where we should go. You know, talk about people being indoctrinated or people being wrongly educated by society. We need to be rightly educating them, and that's what this does. That's what this legislative priority would do. That's what a bill does, and that's how we lead in bringing the culture where it should go. That's certainly been the way that a lot of, on the other side, Democrats or liberals have done a lot of things as well, right? Push the antithesis, and things may happen gradually, but they're always pushing what they're
Very
really
good.
want.
That's all my questions. I want to thank you again for your time and
Thank
for
you.
your friendship, and to the chairman, thank you for the latitude to tribute. Thank you.
Thank you.
Mr. Chairman, J.R. Haas, SD7. I'd like to ask a question, two questions actually. Thank you, looking for time. Let's see. So the first question is, in the Texas abolitionist strategy, I think the first step is to pass the pre-NDA bill. Do you believe that the pre-NDA bill, that as you understand it, will it actually protect any children or any preborn children?
I do not believe so. So the Prenatal Non-Discrimination Act has passed throughout the country. I mean, where it's been passed, I'm not saying it's been passed throughout the country, but where it has been passed, it says that an abortionist cannot commit an abortion if the intent in getting the abortion is a discriminatory reason or discriminating on the basis of certain classes, you know, sex or race or disability. That's what the Prenatal Non-Discrimination Act does. It prohibits, you know, those kind of abortions. But as a lawyer, if I'm thinking, okay, if I'm putting on the other hat, I'm the lawyer for this abortion clinic, what am I going to do? I'm going to put on the form, I'm just going to put a check there. It's like, you're not getting an abortion for one of these three reasons, are you? No, of course not. Well, then there you go. Or even if the mother leaves it totally unchecked and no reason is ever stated, she can have an abortion. Because you can have an abortion for no reason whatsoever. You just can't have an abortion for one of those reasons. So I believe that, quite frankly, I believe that PRENTA is, it might help us, you know, up our ranking as far as being a pro-life state, but I don't think it's actually going to save any children.
And second question. So I think one of the assumptions, or I think we heard from an earlier testifier, that one of the ideas that the Fifth Circuit Court of Appeal, which I believe is the most conservative federal court in the nation, that this court is going to actually, you know, rule in favor of this pre-NDA, right? I guess it's been heard in Indiana, but not yet in the Fifth Circuit. The Heartbeat bill has already been heard by the Fifth Circuit Court of Appeal. Is that correct? And can you speak to that decision and what might undermine this strategy altogether?
Right. Well, first of all, I would say even if PRENTA does end up in front of the Fifth Circuit Court of Appeals, and even if they uphold it, right, even if that happens, again, I don't think it's actually going to save any children. But that said, as far as the Heartbeat bill, we've already, just since December, the Supreme Court, or the Fifth Circuit decided a case considering a 15-week ban in Mississippi, and they struck that down. And they said, you may not do any kind of bans of abortion, is what the Fifth Circuit said. And then a few months later, they considered a Louisiana heartbeat bill, right? I know last legislative session, a lot of us were looking back, like, well, we didn't get anything passed. Look, Democrat governor of Louisiana passed a heartbeat bill. Why can't we pass something here? Right? A lot of us were somewhat jealous. Well, that's already been struck down too by the Louisiana court, or sorry, by the Fifth Circuit, which is over Mississippi, Louisiana, and Texas. So again, what we're trying here, when we're talking about making a legislative priority, is something that our own circuit has already struck down.
The chair recognizes the gentle lady from SD5.
Madeline Lucier, SD5. Have you submitted specific wording for this?
We have, yes, we've submitted it. It's come up through numerous counties, but then we've also submitted it directly to the members here.
Okay, so my understanding correctly, you talked about the definition of abolished abortion, which is different from what other people have defined as abolished abortion.
From what other people are calling Texas Abolition Strategy, correct?
Okay.
Any other questions? Seeing none, thank you so much.
Thank you very much.
The committee calls Mr. Matt Long. On deck is Mr. Josh Jaros, Christina Harup, and Suzette Griffin. Please state your names, SD, and delegates next.
District 24, and I'm a delegate. This is my third convention, only the second one. I've come to the pre-convention. After I went to my first convention and I got there on Thursday, I found out all the work had been done. And so the last two, I have come on Monday and stayed through the week to see the hard work done. I am a member of the Fredericksburg Tea Party, and we live close enough to Austin that for the last 3 sessions we've been organizing people from the Hill Country to go to Austin on a weekly basis, and we train people to testify, and we fight for the platform and for the priorities of the Republican Party, where they line up with Tea Party principles. And so far, all the priorities within the Republican Party do line up and have lined up in the past with the Tea Party. So we're very, very happy to go up there. We do a lot of work. We build relationships. I know a lot of people in this room, not only in front of me, but behind me, just because we run into Austin, run into each other in Austin all the time. One of my biggest issues that we have up at the Capitol is when we walk into an office and we mention something that's a priority or the platform of the Republican Party, and we get laughed at. We get laughed at by Republican representatives. Laughed at for bringing up the platform. We have our people take notes. I have all our people take notes, and so we have notes and the names of the offices where we've walked in, and we bring up the platform or the priorities, and they laugh and they say, "Are you serious? We don't represent the Republican Party. We're not here to represent the Republican Party." And then I come back into these rooms and I recognize literally the 10,000 man-hours put into creating the platform and the priorities. And I watch you guys come up here at the crack of dawn on Monday, work all day Monday, late into the night. I have heard one of your members earlier say it might be 11 or 12 tonight. If the rest of y'all didn't know that, I hate to break the news to you, but one of the people sitting around here said it may be that late. This is a tremendous amount of work y'all do, and I want to thank you because I know the paycheck is not very big, and so I want to thank you so much for the work you do, but I would really like to strongly suggest that at least once during the next legislative session, you go up to your representative's office and your senator's office and tell them how hard you worked, what you had to sacrifice, the money you spent this week, the time you spent, all the crapola we've been going through with the city of Houston, and yet you showed up here, you're doing this work, and you got people with an R by their name who are going to ignore every stinking thing you're doing in here. And so I want to ask you, please, I want to thank you for your work, because I do appreciate it. We appreciate it. Those of us in the Republican Party, we appreciate your work. And if we didn't, we wouldn't be here either, all right? And so it really hurts. Thank you. So it really hurts all of us when we go to the Capitol and hear that. And I actually took copies of the platform towards the end of the session, the whole thing, printed them out in my own cheapo printer at my house, put them into manila envelopes and took them up to the Capitol and was handing them out with a little note that said, you guys need to read this, the session's almost over and you haven't done much of what's in here. All right, and so, and we got crap for that. Listen, we got in trouble for that. And so, that's not what I came up here to talk about. I came up here to talk about constitutional carry, but they've done such a good job of doing that. And this lady, thank you very much. Number 27, that's your right, number 27. Everything I was going to talk about, she asked and got answered a while back. And so, thank you again for the hard work you do. Thank you very much.
I have a question for you. Chairman, J.R. House, SD7.
Okay.
This is my first time serving on committee, but I was here 2 years ago, and I thought we walked away with a fine set of priorities that were taken. And I think at the end of the session, everyone looked at it and we're just, felt like we were left lacking, that we weren't accomplishing what we did. You said you were being laughed at when you take these into your legislators. In your opinion, do you think we need to soften this language so it's more digestible for them to do it?
No, that's not the issue.
Sorry.
No, go ahead, I'm sorry.
So, do you think we soften the language, or do we maintain our principles, and how do we actually get them to implement these, in your opinion?
Well, I spoke up in the Rules Committee earlier today on Rule 44. I think that we really need to start using that as grassroots people. We really need to start using that. We have to hold these guys accountable. Once they get their R by their name, and especially in the area where I live out in the hill country, once you get that R by your name, you can do anything you want to, because most of the folks up there, ours are so safe in these rural areas. And a lot of it has to do with voter apathy. We're not paying attention. Our friends aren't paying attention. And so they go in and they see the R, and then those of us who try to hold them accountable to that letter, we just get nailed. Just get nailed. And so I think it has to do more with, the language, and stick with your principles, please. But it has to come from the grassroots, have to have the ability to call these guys out in a real and meaningful way. And so I called earlier today for the strengthening of Rule 44, and so that's what I really think is more of the solution.
Sure. One moment. Chair, Mr. Ramsey was first.
Okay, I just had a little bit of a question, maybe a little tongue-in-cheek like JR's was. But first of all, I thank you, because I know many times I was at the Capitol, you always there. In fact, it's where I met you in the first place, was it's something in the Capitol. So thanks for you and the Fredericksburg Tea Party. Y'all were very active, obviously. But tell me one thing. Do you think it's the party's fault, or do you think it's the legislature's fault that these things didn't get done?
I think it has to do with the leadership. It's who the House chose as a speaker. Has a tremendous amount to do with it. In fact, I'd say nearly all has to do with it. And then when the speakers choose the committee chairs, one of the issues that I'm being told up at the Capitol is that it's a tradition that you give half the chairmanships to the other party. Folks, that has got to stop. That's a serious I just can't see Nancy Pelosi turning over, half the seats. And honestly, I'm not sure, and there will come a day, and some of you have been around long enough, there will come a day when the Democrats do have the House back in Texas. And honestly, under the way things are these days, as divided as we are, I don't think there is a chance that the grassroots, the Democrats, will tolerate the Democrat leadership giving committee assignments to Republicans, committee chairs. I don't think they would tolerate, and so I believe our grassroots has to stand up even stronger to our leadership. Now, it comes down to who gets selected in the House, and the committees, and the calendar, specifically the calendars committee. There's so many of those little things where the bottlenecks all happen, and it's the rhinos in the Texas House that we deal with.
Really brief. Thank you for your time, and I think everybody here really agrees with you. Thank you for testifying before rules. Thank you for testifying before here. Have you also spoken to platform? Because to me, this is something that we need at all fronts be completely united on, so they understand we're serious. So have you gone and spoken this passionately before the platform committee yet?
I will tomorrow.
Okay.
I'm here all week.
Tell them we sent you.
All right, I will. I'll tell them. You're recognized, sir.
Yes, thank you. Shelby Williams, SB 8, introducing Paul Hodson, SB 22. I'm going to try to put this microphone close to the iPad. Paul is a committee member joining us remotely because he is recovering from COVID.
Hey, Paul.
We'll try this. Go ahead, Paul.
All right, hey, can you hear me?
Yes.
Paul Hudson, SD 22. Matt, I just want to reiterate what Mark said, the chair. Thank you so much. I know we've had lots of conversations. We're going to have lots more conversations. We lean on you guys in Fredericksburg to kind of be the anchor point for us, the grassroots at the Capitol. So that really, I just want to say a big thank you to you for leading the way and showing up at the Capitol.
Thank you, Paul. Hope you're getting well.
I am. Thank you.
Paul's had the Kung flu, if y'all didn't know that. You're recognized, sir.
Chip Howell, SD 24. I also want to thank you so much and the people that go with you to Austin work. I happen to be reside in one of those districts where the representative does not necessarily represent the party, and he does not vote that way. And so I understand exactly what you're talking about. We've got to start really working with the people who have the backbone to do the work that needs to be done. We have to make sure that we're working at the grassroots level. We are getting the information out to the voters as well, that their representative is representing special interests, such as the wealthiest person between Austin and Dallas, and not the people of the district, and not Texans. And we have to continue to get that message out there until voters finally get tired of it and they get voted out. But we also have to put pressure on, as you are at the Capitol as well, because they do see you. When you knock on their doors, when you're in their face, they do see you, they do hear your message. Thank you again.
Thank you, sir.
Any other questions?
Thank you for the opportunity. I appreciate it.
Matt, thank you so much. Committee calls, Mr. Josh Jarrett. On deck is also Christina Karab, Suzette Griffin, and Ryan Richards.
Good afternoon, Josh Jarrett, Senate District 4, I'm a delegate here to the convention. And I want to take this opportunity to express my support for putting in the strongest language that we possibly can to protect the unborn. I'm fully supportive of abolish abortion. Some really good arguments. I think that our party has somewhat become desensitized to this issue. I think we've heard it's been going on for so much years. These are lives. These are children being murdered. I think there's a lot of people in our party that have become frustrated that our legislators are not doing more. I will say this, I know there was a lot of controversy last year on what we should pick for a legislative priority. Some people thought we should go for the whole apple, some people thought we should try to include the bites to it. I say, let's get whatever we can. If we can save some, let's save some. If we can save them all, let's throw everything that we have at this issue. You know, sometimes when it comes to passing legislation, you're not going to get everything right away. But if we could save some during that legislative session, why would we not take that opportunity to do that? But I also don't want that to be an excuse that if we can get the whole apple, let's go for it. But I would encourage you all to look at some of the language that we've had in the past and try to make it stronger. Try to impress upon these legislators. Look, this is the grassroots. This is us as the party. Let's send the strongest possible message that we can, that we want them to do everything that they can. And as a party, let's go ahead and support them when they start filing this legislation. I'll end right there. Thank you.
Do any of the committee members have any questions? Committee calls Christina Herod. Please state your name, SD, and delegate status.
Hey, I'm Christine Harhoff. I'm with
Feel free to
SD.
adjust the microphone.
Okay, we'll do that too. Christine Harhoff, SD4. I'm an alternate and speaking against the resolution to refer to women and to treat women as the victim of the abortion right along with the baby. I minister to actively aborting women. I know how they think. I spend my days reading their emails. Sometimes I'm up in the night with them before they get their abortions. I know actively aborting women, like many of the organizations that may have spoken here to you, perhaps do not. And the reason I make that distinction is because many of our pro-life organizations, they minister in the context, or they get their information from our beautiful pregnancy health centers where my friends work. And we have to understand the difference that those pregnancy health centers that do such a great job with these women are ministering by and large to women who come to them for help with their pregnancies. That is not by nature of the fact that they come to our beautiful pregnancy centers for help. Those are not actively aborting women. So the ones I work with have scheduled abortions. I minister with repentant post-abortive women who will tell you they have been redeemed by the Lord Jesus Christ, and they stand with me on this issue that I put on your desks here. So once again, the women I minister to are the 55,400 mothers who have seen their babies on sonogram. They've seen their little arms and their little legs and their little pug noses on sonogram by Texas law. And they still choose every single year, 110,000 in between legislative sessions, to abort their babies anyway. They get the Woman's Right to Know booklet, and that doesn't faze them. They still schedule their abortions and go through with it anyway. We've got to remember that there are true mother victims of the abortion, and those look like the 11-year-old locked in the basement by traffickers. But that's not the typical everyday American abortion scenario that we see in America, in Texas. You know, the mothers who schedule their abortions, when they schedule that, they can refuse to drive there. They can call out to the sidewalk counselors for help. They can call 911 if anybody is trying to force them against their will to get that abortion. They can kick and scream. They can refuse to get undressed. They can refuse to hold still on the table. They can refuse to swallow the pills. If the pills were placed in their mouth against their will, they can spit them out. But this is not what we're seeing when we minister to these mothers. We're seeing that they, by and large, want their abortions. They want to do that. They drive past the pregnancy centers, refusing the help that we're offering them so that they can get their abortions. You know, in China, where women have been truly forced to abort, their homes the doors to their homes are kicked in by armed guards who grab the mothers while they're kicking and screaming, and they fight against those armed guards with everything they have in them to protect their little ones. That's a true mother victim, right? Somebody who's fighting, but not women who are paying their hundreds of dollars or thousands of dollars and signing the paperwork that gives the abortionist the legal permission to have out their child. And sometimes I think, you know, as one center to another, speaking about other centers and the victims on this issue, how dare we consider the woman in Texas walking in voluntarily requesting the abortionist to take her baby? How dare we equate that with the mother who's had her door kicked in by armed guards, or the 11-year-old locked in the basement? Those are not both equal mother victims of the abortion. In the typical everyday American abortion scenario, the baby, and only the baby, is the victim of the abortion. The victim is the one left behind in the medical waste freezer. It's not the one going home with a heating pad at the end of the day. And I say that as gently and as respectfully as I can. It is one of the greatest hindrances we have to reducing the number of abortions on Texas soil, to think of the mother as the victim, and to continue to speak of her as being forced into her abortion. Well, that's not really happening. And we have to get that clear in our minds. Those who minister outside of the clinics, those who minister in the pre-abort support groups with actively aborting mothers, guys, the spirit with actively aborting mothers is as vile as the pictures and the videos that you guys see from the LGBT parades. They are loud and proud women who will use the term "killing my baby" unashamedly because the law has not restrained them from doing these things to their children. You know, I posted that I was going to be speaking here today, and one of my pro-abort hecklers on my Facebook page said, what do the Republicans think we are, stupid? She was offended by our resolution here today to treat women as if they're too ignorant to know what they're doing in an abortion. You know, by definition, victims are persons harmed. They are the ones injured or killed as a result of a crime. They're the ones left behind in the medical waste freezers, in the typical everyday American abortion scenario. By definition, to be forced means that the mother could not choose otherwise. That's not America. America, the woman can, by and large, choose a life for their babies.
Hi. Oh, hold on one moment.
Is that one?
Yes, ma'am. Do committee members have any questions? Yes, gentlemen. Yes, sir.
Yes, Mr. Chairman, J.R. Haas, SD7. Thank you, Christina, for your testimony. To your knowledge, of the 55,400 mothers that chose to terminate, how many cases was it the case where the doctor either tricked or forced the woman into the abortion?
I don't think the doctors have to trick or force the woman. I don't know where we get that idea that Planned Parenthood physicians are hog-tying the woman down in the clinic. They don't need to do that, guys. There's enough women lining up down here in downtown Houston, outside of Houston Women's Clinic. There's so many women, they're filling up an overflow parking lot and parking them down, you know, the streets of Houston and marching them in with escorts who want the abortion. They're not there being forced into it by the abortionists. That's a myth, I believe, of our pro-life circles.
So you'd say in all these cases, it's really the mom is basically wanting something to be done, and these other people are just helping her, assisting her to...
Absolutely, and we know that because she's signing the paperwork. Very clear. There's even clinics. You know, they don't want to be sued for having aborted somebody's baby. Women sign the paperwork. They pay, they cooperate. You know, abortions can't happen without the cooperation of the mother in the typical everyday American abortion scenario. She's climbing up on the table. She's swallowing the pills. And we as women, we don't need exceptions, you know, in the law. We don't need to be coddled under the homicide law just because we're women. We need to have equal justice for the babies in Texas. There is no way to enforce the law unless there's criminalization going forward. These aborting women are far too determined to abort their babies than to just not do it on the honor system, you know, just because it's illegal. There has to be punishment. There has to be enforcement. Any other questions?
Thank you. The committee calls that
So, Ryan Richards, Chairman, Gaines County Republican Party, delegate,
state your pronoun.
ST31.
Objection.
Mayor.
So we have a list of resolutions that we passed from our county, some of which belong on the platform, others of which could be considered for legislative priorities. I think the top issue that's in everyone's face right now is the virus issue. It seems pretty unanimous that people are pissed that the governor thinks that he can just write law. You know, we need to rein in the executive powers, emergency powers of the governorship. And so, I mean, he has the authority to call a special session of the legislature. And then we could have public comment, we could have actual experts as opposed to Dr. Fauci, and people who are not actually involved in gain of function research. So one of our resolutions, it reads, no virus or pathogen, no matter how severe, shall ever constitute a legitimate justification or reason to curtail our constitutionally guaranteed fundamental rights. So, I mean, that, I believe, could be a legislative priority for sure. And we have the vexatious litigant thing, probably that, I don't, it's up to you guys where that belongs, but, and then free speech, online free speech, I would say that would be number 2. Because if we continue to lose our online free speech, it's all over. The First Amendment is the First Amendment for a reason, and the Second Amendment is the Second Amendment for a reason. Because if you lose your First Amendment, the only recourse is the Second Amendment. And this includes online speech. We are losing right now the ideological battle online to a bunch of Marxists. Mm-hmm. And they're taking our children. So one other thing thing that I wrote, it probably is not a legislative priority for this session, but I suspect that it's about to be, because things are getting a lot worse very fast. It reads, a mitigation contingency plan being necessary for our great state of Texas due to our invasion by radical leftists from California and other such hellholes. Plans must be put in place to politically quarantine Austin and other such areas affected by the liberal pathogen if our state flips blue from its spread. We, the producers residing in rural Texas, refuse to be ruled over by these severely misguided people who seek to stifle oil and gas production, enslave us with more taxes, and groom and indoctrinate our children. Basically creating city-states. I may be controversial, but I think that these radical left Marxists, our country is getting more and more separated, and we need to do something, or it's going to come to a head. We need to do something to prevent violence here, because we need to push for a peaceful separation of the radical left and the rest of us who have our heads screwed on straight. So the radical left needs their own little corner, they say in Austin.
Sure.
But they're not going to tell me what to do. I'd rather die. I'm not going to live in a Marxist utopia. So, and I would defend that. I would be willing to die for my country right here, if need be. So, and there's a lot of people that are in the same mindset. So, we should start that discussion. Thank you for your time.
Does anybody have any questions? Thank you so much, Ryan. Next in order, the committee calls, I believe, Angela Smith. And on deck is Terry Hall, J.R. Haas, and Mr. Joe Hoyman.
Point of order, sir. I just want to remind the speakers to please stay on one topic.
One topic, 5 minutes. Just the SD, delegate status, and the issues.
Thank
Thank you. My name is Angela Smith. I'm from Fredericksburg, Texas, SD 24. I am a delegate here at the convention for, I think, the third or fourth time. Topic today, Texas is under attack from our governor, much like the Democrat governor of California. If he or Republican politicians continue to rule as Marxists, all of what we as Republicans are working on here today and expect from our representatives is lost. 3 examples, I've got more. He's purchased software for $300 million to enforce contact tracing, not to mention statewide mask mandate and the closing of businesses, meaning people putting people in jeopardy. He is not protected. He has not protected our election integrity in this state. It's a disgrace through this state, this SOS. I have been at a mining station. I have to call the Secretary of State over and over to try to get these people who will not follow code, and when it comes to counting the votes. And we have paper ballots. I mean, it's a no-brainer. But they just, you know what they told me the last time? We'll see you in court. They made me sign something that was against election code. Yet my governor is doing nothing to protect me out there. It's almost scary, to be honest with you. He didn't address any of the priorities last session. I stood there and watched him talk about everything. They talked about everything. Priorities. Then he never did bring up constitutional carry. See how many people out here are interested in that? How many people out there think that Republicans are working on stuff like that? Oh, they think that's what's happening until I tell them, and they can hardly believe it. They hardly believe that the Republicans are laughing at us when we walk into offices and talk about priorities. What a joke. I'm sorry, I'm very emotional about this. Well, last and not least, it is clear that he made it clear that he wasn't going to show up here. You know, the last time I looked, this is our convention.
Right.
He is invited.
Right.
But he opened the door for the cancellation of this convention. It is the largest state convention in the country.
Right.
And he has the audacity to say he's not going to show up.
Right.
That's not my governor. We must demand that the legislature address this issue, unless he calls a special session, which he's not going to do, and he doesn't care. And where is he tonight, I'd like to know. Probably sitting somewhere in a cush, posh, somewhere with some donors, because I know the donors. Republicans must make sure that we are never again in this situation. I understand that the committee is crafting language focused around emergency powers under Texas government code. I just stated to you, it's not about just emergency powers. He's violating everything. Therefore, I call on added language giving Texans the ability to recall any governor that acts like this. Thank you.
Thank you so much. The committee calls Terry.
Howdy, I'm Terry Hall with SD24, and I am a delegate. I've been working on transportation and toll road related issues for a very, very long time. And like all of you, I'm so frustrated that our top priorities continue to be sidelined by falling on deaf ears within our own party. And frankly, this should be a very big Democrat issue if they actually believed in social justice, because it hurts the poor the most. Transportation often gets overlooked, but this is a true core function of government. This is what they actually should be doing and funding. Think about what it took you just to get here in the circumstances that we're in. We can't go about our daily lives for very long without utilizing our public road system. As you look at our top 5 legislative priorities, we ask that you consider taking the tolls off the road when it's paid for, and toll collection reform under some kind of a tax relief priority. The tax burden this has created is unsustainable. When tolls can now exceed $3 a mile in peak hours on the North Tarrant Express to use a public road just to get to work, we have a major overlooked tax burden. This is not only equivalent to property tax, It's even more depending on how many drivers you have in your household that face this on a daily basis. It's creating crushing debt. In fact, Senator Hall calculated for us as we were going into last session what he believed would be the cost over the life of someone's working career. It would exceed $100,000 in toll costs, as that's just today's cost. That's not the escalation that happens every year. That's like taking away a college education for that family. That's where toll collection reform piece comes in, because how are so many people getting upside down on their toll bills? The number one reason is their payment card expires, and they don't immediately notify their toll entity about it. They dink you for, and they call it a toll violation for every time you pass under a toll gantry. That can be 4 or 5 on your way to work, 4 or 5 on your way home. That's maybe 10 a day. It takes less than 30 days to become what's called a habitual toll violator of 100 toll violations. So in less than 30 days, you are now considered a criminal in the eyes of Texas law. It is a criminal over what really should be a civil offense of an unpaid bill. And they can impound your car and leave you standing on the side of the road, which adds another $800 to $1,200 onto what you already can't pay with your toll fines and fees that have now collected because you didn't know your payment card didn't work. And the toll collection and our toll authorities around this state do not have to notify you when that happens. They have an incentive to keep cha-ching, getting all those fines and fees tacked on to where we are now creating a cycle of unpayable debt for our citizens. And what we're doing is ultimately unconstitutional in the first place. So we look at constitutional carry, right? We look at the right to life, which is also, in our view, a constitutional issue, right? A right to life. That's why the group's called Right to Life. This is also unconstitutional. You may not know that. We are protected in the Texas Constitution, Article 1, Section 26, against perpetuities. And this is what we have, is perpetual. Always find use for that money, and it will never come down. And in state law right now, they think they've got the authority to continue this, and they're violating the Constitution. So our legislators are out of control on this issue as well. I'm sorry to report. But we need this issue to be elevated to a legislative priority, just like so many you've heard here today. I don't envy you and don't want to be in your shoes right now. And we've been trying to get these reforms passed, I'd say at least at the 6 out of the last 8 sessions. And we say we're the party of criminal justice reform, which President Trump has done more than our legislature has in recent history, has put elections over an unpaid toll bill. Austin, this is capturing a whole lot of drivers besides just those that live in Austin. 2 million drivers take people's cars because
most of us here are precinct chairs. We need to do a better job of educating neighbors. We need to get these guys out of here. The guy talking about Texas leadership, you know, I brought her in my county to ask Speaker Bonin to resign because I thought, try to. And I think we need to be doing that when it comes to our elected officials not implementing the priorities that we delivered from this committee. And so I just appeal to you for Caesar. It's like Caesar pass up that abortion needs to be outlawed, and it needs to be outlawed as quick as possible. Any questions? Come on, y'all. All right. Thanks.
It's an honor serving with you. Thank you so much. The committee would call Mr. Joe Poyman. And on deck we have Amy O'Donnell, Mr. W.O.J.C. and Jackie Sheetal. Please take your SD.
Yes. Hi, my name is Dr. Joe Poyman. I'm a delegate from SD 14. I'm the executive director of Texas Alliance for Life. Thanks for your attention. I want to address the dispute resolution process of the Texas Advanced Directives Act, and I ask that you not try to remove that in legislative priority. Here's why. Texas Alliance for Life strongly supports the Texas Advanced Directives Act and its dispute resolution process, a vital part of the act. The The process is supported by the Texas Catholic Conference of Bishops, the Texas Baptist Christian Life Commission. We believe the law is good public policy and it's constitutional, while being open to improvements. The Texas Advanced Directives Act was signed into the law by pro-life Governor George W. Bush in 1999 with the unanimous support of the Texas legislature and pro-life groups including Texas Alliance for Life, Texas Right to Life, the National Right to Life Committee. The act replaced a law that lacked enough protections for patient autonomy. There was a problem in the law. That's why this law came into being. And the law has been balances the family's autonomy regarding end-of-life medical decisions with a physician's conscience rights to not be forced to order medically inappropriate interventions to prolong a patient's death using means that cause pain and suffering without proportional benefit. We're not talking about extending a person's life. We're talking about cases that are extending a person's death, a person who is terminally ill. In rare cases, when the dispute cannot be resolved, provide safe harbor from liability for a physician. However, the safe harbor is available only after meeting several due process requirements, including attempting a transfer, and that is the goal of the law. When the family wants one course of treatment and the patient says, I cannot provide that to your loved one because it's harming the patient, not helping, just extending the person's life, like another round of chemotherapy that is just going to be futile, but very difficult for the patient to endure. The goal of that is to find an alternate willing provider, a transfer, and that frequently happens, but not always. Of 23 states, now it was said that there's no other law like this in this country. That is simply not true. In fact, 23 states, including Texas, allow safe harbor for a physician to withdraw life-sustaining interventions. But of those 23, Texas provides by far in fact, Texas law compares very well with other laws in other states. It's unique in balancing the patient's or family's autonomy regarding these end-of-life medical decisions with the physician's conscience rights to not order medically inappropriate, painful interventions to prolong the patient's death. A benefit. In rare cases when this dispute cannot be resolved, the Texas law does provide that safe harbor. But it's amazing. There are 12 very meticulous provisions that have to be checked off before that doctor gets safe harbor. One of those is to, for at least 10 days, have a legal responsibility to attempt. We heard about Tinsley Lewis. Did you know there were 20 hospitals, top pediatric intensive care units consulted around the country from Boston Hospital? She's dying. She's terminally ill. You heard about Chris Dunn, the poor man in his 40s who supposedly the hospital was trying to kill Chris Dunn. Well, guess what? When these records go to court, when these cases go to court, the public can see the medical records. That man arrived in the hospital terminally ill with pancreatic cancer, and he was forced to survive for 9 weeks. During that time, the reporters said there was rotting flesh smell in the room, and when he died, he had 20 pints of fluid removed from his abdomen. That's 5 gallons of fluid. That poor man suffered. That's fine. Thank you.
Does committee, Ms. Lewis?
Janera Lewis, SD 27. Thank you for speaking. We had someone state that hospitals wishing to terminate or allow patients to pass withdrawal support are reluctant to facilitate the transfer of these patients to another facility. Does that sound correct?
All the cases I'm familiar with, that is absolutely not true. In the case of Chris Dunn, there were 60 other providers around the country and in Houston that were consulted. By law, they have to attempt to do that. And they're well positioned to. They do transfers all the time. The only time you hear about it is when patient is too sick that no other facility will accept them because they can't do any better than the one they're in already. But that's just blatantly false.
Okay, thank you for that. Oh, I'm sorry.
Go ahead.
Additionally, the statement was also that paperwork that these hospitals or doctors are providing to other facilities is outdated and or inaccurate or incomplete.
You know, in the Tinsley Lewis case, there was expert medical testimony in the district court in Fort Worth, and one of the 5 attending physicians, a specialist in pediatric heart therapies, said he spent hours on the phone with Boston, Cleveland, Mayo Clinic. That is just, from the cases that we're familiar with, that's untrue, and if that were true, it'd be a violation of the law that we have in place.
Okay, I'm sorry, one more and I'm done. Do you know approximately annually how many people have support withdrawn from them using this?
We think it's on the order of a couple dozen per year. Most of the time they're resolved, the disputes are resolved. And you know, 99.9% of the time, physicians should follow the wishes of the family. These are only just very extreme and rare cases.
You're recognized, sir.
Gene Pack, SD 13. Joe, I want to thank you for the many years of your hard work of trying to protect life in the state of Texas. I also want to say to you that you were speaking just now about Chris Dunn. Wasn't that case here in Houston? Could you expound more on that? Because your time expired.
I'll try and keep it short, of course, but Chris Dunn was a man, 46 years old, who was in a hospital in Pasadena. They couldn't take care of him. They asked for a transfer to Houston Methodist, which is one of the top ICU hospitals in the country. He arrived with pancreatic cancer on a ventilator. He was provided all interventions for about 3 weeks. The mother, he had no advanced directives, he had no children, he was never married. His mother wanted interventions continued indefinitely. His father wanted to transfer the treatment goal to palliative care so Chris could die naturally. He had expressed his wishes. He never wanted to die in a hospital. In fact, he had locked himself in a room so he couldn't be taken to a hospital. So there was this dispute between the mother and the father. What is the hospital supposed to do? Who are they going to get sued by? So they went through this process, tried to transfer him, as I said, to more than 60 institutions. We didn't hear about that from some groups that were advocating for overturning the law. 60 other institutions. They did a really diligent job, and he died, I think, a very unfortunate death after a great deal of suffering, about 9 weeks after he was admitted.
Mr. Gaspar.
Jonathan Gaspar, SD12. Thank you for your time, Dr. Poyman. Just out of curiosity, are you a medical doctor? Or
No, I'm not. Okay. I'm an academic engineer, PhD engineer.
Other questions? Yes, ma'am, in the back.
Bonnie Lugo, Secretary. Dr. Coleman, you are the director of a pro-life organization, is that right?
Yes, Texas Alliance for Life.
Okay, but I'm feeling a disconnect. I'm not understanding your position on this 10-day rule. What brings you to speak?
We think that life has to be valued. We want to protect innocent human life from conception to natural death. But that does not mean forcing physicians through the law, threat of lawsuit, or threat of criminal penalties to harm their patients by forcing the body to stay alive with painful means indefinitely, even at the request of the family. That's not what pro-life means. And one of these laws we just passed in Virginia, very similar to Texas, I mean almost exactly like Texas, just 2 years ago in Virginia. The Virginia affiliate of National Right to Life approved that law, as Texas Right to Life approved this one back in 1999. So it's just that pro-life does not mean forcing a body to stay alive through methods that cause pain and suffering indefinitely. But if that's what the family requests, let's find an alternate willing transfer, because as pro-lifers, we don't think healthcare providers should have, pro-life doctors have come to us and said, please don't let them take away this protection, because we don't want to have to be forced to hurt our patients indefinitely.
Mr. Gaspar.
Jonathan Gaspar, SD 12. And just for my own clarification, you could help me, because on Ms. Lugo's statement right there, I'm finding a disconnect as well. It sounds like you're putting lipstick on euthanasia, and I don't understand. I just don't understand.
We oppose assisted suicide, we oppose euthanasia. Euthanasia is the intended killing of a patient. That is not what's going on here. Everyone is going to die, and sometime you have to let the person die peacefully. But dying in an ICU is not a natural death. It's a very painful death. And the goal of an ICU is to make somebody better. But if you're forcing that person's body to stay alive indefinitely, and you know they're going to die, it's just prolonging the dying process. Why should we not allow a physician to transfer to another patient? Or let's switch treatments so that it's palliative care. The law does not allow anybody to be starved to death. We worked very hard in 2015, so that was added. We are not talking about DNRs without consent. That got changed in 2019. The law, all the pro-life groups got together on that.
So you're telling me that this 10-day rule and what you're discussing right now does not deny the required steps such as food, ventilators, water, things like that.
Food and water are not covered, but
it doesn't just cut it off, and then, okay. So that's what you're saying, is you're saying that does not happen. They're not denied food, they're not denied water, and they're not denied ventilators.
I didn't say ventilator, but I said food. I said food and water. That is a very serious violation of law if somebody starved a patient to death.
So denying that does not count as euthanasia in your definition, by denying any of those things to a patient.
You know, if the family says, doctor, please don't keep him alive. He's dying. Take him off the ventilator, which is a really tough thing to endure, extremely tough thing to endure. And please take him off. Let him die peacefully. If the family asks that, that's not euthanasia.
Again, I'm speaking from my own ignorance. From what we've heard from the testimony is that these decisions are made by doctors against families' wishes. What you're describing is if it's a family's wish or it's an end of life. But some of the testimonies I've seen and some of the things that have been said even today, and I'm drawing on things that are beyond today,
Sure.
that there are families whose wishes were gone against.
Yes, the family is not always right. I mean, we know that. If a family asks for assisted suicide, a doctor should not be forced by law to provide assisted suicide.
Point of order, that's really debating, and that's getting off what the question is.
I apologize.
We have a rule against debating by the, yes ma'am, you're recognized.
Thank you. Julie Pickard, SD 11, and I just need a little bit of clarification for you. Our current palliative care and hospice care, does it operate underneath this act, underneath the Advanced Directive Act?
Well, to the extent that it cannot be denied a patient. Palliative care under this cannot be denied a patient. So pain control cannot be denied, food and water cannot be denied, nursing care cannot be denied under this law.
Thank you.
Any other questions? Yes, sir, Mr. Shelby.
Yes, thank you. To clarify, Shelby Williams, SD8. It seems to me that the testimony we heard earlier and this are two sides of the same coin, just going from completely different directions. One is stating what we've heard earlier is don't force the removal of artificial care if it is against the family's wishes, or the patient's for that matter. Don't force that removal. This is saying don't impose that removal, or don't impose that artificial care if it is against the wishes of the family or the patient. Is that correct?
No, not exactly. First of all, some of the testimony, I think I counted more than a dozen inaccuracies that were stated about the law. But in this case, sometimes the family is asking for something that is harming the patient. Doctor, can you please do another round of chemotherapy for my father? The doctor says, I'm sorry, I can tell you it's not going to do any good. It might extend his dying process for another week, and it's going to be very difficult for him to endure. I will help you find an alternate provider, but I will not do that because ethically, I do not want to harm your father. And some, in very, very rare cases, that's legitimate.
Understood, thank you.
Leanne, you're recognized.
Lolland Cloud Bees in District 29, excuse me, 28, I knew I was going to get that, 28. Doctor, do you think that perhaps some of the issues that we have with this law is not the law itself, but that perhaps it was not applied as intended?
As intended, perhaps, we have anecdotes that surface. The hospitals cannot talk about what's really going on because the state and federal is out on the steps of things. So we don't know what's really going on until there's a lawsuit, and then the affidavits from the physicians, for example, saying that the patient is terminally ill, that becomes apparent. Otherwise, we're totally at the mercy of just one side. So we don't, and I'm not going to say that every doctor in Texas follows the law. I don't know about that true to be any profession. So, it may not be the law, it may be bad application or just be misconceptions or inaccurate representation for how the law is being applied. Well, however this turns out, I'm sorry. You have a question?
Since there's not a chairman paying attention.
Sorry.
Our vice chair is in charge of the testimony. Our second vice chair.
Way to go.
I'm Rich Scott, SD9. Joe, hello. One of the questions I have, has Texas Alliance for Life or yourself advocated for any patients to help them through this process directly over the last 15 years?
We don't provide any social services, but we work very closely with issue groups who do, like the Catholics who run numerous hospitals, Baptists who run hospitals, and other independent hospitals. So we get our guidance from those who are right in the mix of it.
You referred to this as a dispute resolution process, which, to shorten it up, what the dispute resolution process is, the hospital or the doctor, I guess it is, tells the patient what the answer is going to be. And if the patient doesn't like that or they're servants, they have to take it up in court. They have to file a lawsuit from the hospital. Is that true?
Not at all. Now, the beauty of this law is that if there's a dispute, irreconcilable dispute between the physician and the family, and the doctor says, I don't want to provide those interventions indefinitely, then his decision has to be reviewed by an ethics panel in the hospital, which are very common. All these hospitals have ethics panels, and many times they don't agree with the physician. If they don't agree with the physician's assessment that the interventions are medically inappropriate, by the way, it's not a quality of life standard. That's not what's in the law. It's medically inappropriate. That is defined. If the ethics committee does not agree with the physician, that physician doesn't get safe harbor. He can get sued if the patient dies. So the law does have a provision that if there's a reasonable expectation, you can find an alternate provider with more time. They can go to court, and the court can extend 10 days. Many times the hospitals just do it on their own, but the court can extend it. So yeah, there is a remedy in court.
Okay, so that's what the court goes after, but it still ends up with the patient fighting for their life in the hospital bed in a court after they go through the ethics panel. The ethics panel is typically, and tell me if this is true, typically made up of hospital employees of all different kinds.
There are so many hospitals in the state, I don't know, but it's not, it certainly is possible that there are hospital employees, but all the hospital ethics committees I've heard about have at least some citizen members who are not employed with the hospital.
Okay, that's a surprise to me. I think that in the Tinsley case, do you know how many people were on that ethics panel?
I think it was 20, 21.
Yeah, and all of those people were people that worked with the medical staff of that hospital day in and day out.
I think there's some citizen representatives on there. I think we heard that testimony.
There were a couple, yeah, and I was in court that day with you, so I heard that as well. So the panel is made up of people who are all familiar with each other. And if you remember court that day in the Tinsley Lewis case, the attorney for Tinsley's mom asked the question if he would have been allowed as an advocate for the patient in that room. And I think the response that he got from the witness was, we think about that. And then later in cross-examination, did not have any recollection of ever allowing other people in. So you got a room full of 20 people and 2 family members that don't know really what they're doing. Do you think that's a fair scenario?
You know, what we have heard from an ethicist from a large Catholic system in Texas said, you know, a lot of times these doctors come to us and said, I've got this case, and the ethics committee or representatives will say, you know, you can bring that to us, but I can tell you right now, we're not going to grant it. So you need to keep treating that patient. They might go through with it, but the ethics committee, I don't think it's fair to say these are professionals with integrity, is in any way, shape, or form, you know, a rubber stamp or anything. I mean, we just don't have any evidence in it. There's no evidence presented in any of these cases that we've heard in court.
Well, I've just struggled with the term due process there, not to debate here. I've got one further question. With reference was made to the paperwork, and I believe my colleague brought this up, that there was testimony in court that day that her paperwork was 3 months old. Now, that evidence came from somebody from an advocacy group that was working with the Lewises, if I remember correctly. And she obtained the paperwork that was provided to another hospital from that other hospital, not from the Fort Worth Hospital at stake there. You didn't answer the question when she asked you about that paperwork being 3 months old.
Well, as I recall from Mrs. Tinsley Lewis' case in the district court in Fort Worth, one of the 5 attending physicians testified, Dr. Duncan, I think his name was, said the question was whether recent tests had been provided to other hospitals for evaluation. I think it was a very high level hospital in Boston, as is the one in Fort Worth. And he said more recent tests, there was a concern, more recent tests were ordered, and those were sent to Boston.
You don't know the timing of that, whether it was after the disclosure of 3 months?
Oh, it was just days. It was just days before the hearing.
Exactly, the hearing in district court.
Mr. Chair, I hate to break up a great debate, but this seems a lot like a debate.
Okay, well, my question, it is a question on the fact of that case that I thought was relevant, but I think I've had enough time. Thank you.
Any other questions for the delegate? John Murray, SD30. How did they arrive on the 10-day period, and why 10 is the set in stone? Better if it's longer.
That's a really good question, and you know, I was, along with Texas Right to Life representatives, at the table when this law was drafted, and as I said, it passed the legislature unanimously. How did we arrive at 10 days? You know, it was a novel law. All the other state laws at the time that provided immunity for the doctor had no time. The doctor could just make one reasonable attempt to find another doctor. If unsuccessful, bingo, that doctor gets immunity, and he can just let the patient cut off. So 10 days, I think, was the first guess. The legislature has revisited that. I'd like to see some empirical data to actually see how long this actually takes to do transfers. And it's a compromise. If a patient is dying and suffering, each day is another day of suffering. So is 10 the best number? I don't know. Maybe because we have 5, things. There probably is a much better answer, but I think it ought to be empirical, based on real data. And I hope the legislature can revisit it in a real rational way.
Any other questions?
Mr. Chairman, thank you very much.
The committee will call Amy O'Donnell. Please state your SD delegate status and the issue you intend to speak on.
Good evening. My name is Amy O'Donnell. I am a delegate for Senate District 14. I'm also the Communications Director for Texas Alliance for Life. And I'm really proud to be a part of this organization, which was founded over 32 years ago. And since its founding, through its lobbying efforts, we've seen abortion numbers drop in the state of Texas by 25,000 per year between 1992 and 2017. We have seen abortions on minors go down by 75%, and we've seen the Alternatives to Abortion program grow exponentially throughout that time. Last year alone, in the 2019 legislative session, we had several legislative priorities that we saw move through and come to pass. One was doubled funding for the Alternatives to Abortion program, defunding abortion providers and their affiliates, the Texas Alternatives to Abortion Information Act, which fine-tuned something that was already law, requiring abortion doctors to actually hand the Women's Right to Know brochure to an abortion-minded woman so that she could see the stages of development, which we know from FAFSA save lives. We saw the passage of the Texas Born Alive Infant Protection Act for friends like my friend Clara Colwell, who is an abortion survivor. That's especially a win because that does happen, that we have babies that do survive abortions. And then additionally, we saw increased penalties for assaulting a pregnant woman. What I'm here to talk to you today about is something that we would like for you to consider as a legislative priority at the Republican state level, and that is to pass legislation to completely protect unborn children from abortion, beginning at fertilization, through a trigger ban on abortion throughout pregnancy that goes into effect when and to the extent the Supreme Court reverses Roe v. Wade and allows Texas to decide this critical issue for itself. I had some handouts that I went around, that went around this way. I don't know if that made it around to all of you, so I'm going to pass them from this way also. You guys can all look along. Just a little explanation there. Roe v. Wade's unjust precedent strictly prohibits pre-viability abortion bans and laws that substantially limit abortion access. Every state law attempting to ban abortions on non-viable babies, such as heartbeat bans, dismemberment bans, bans on abortions of babies with Down syndrome, and even safety regulations that risk closing abortion facilities have failed. Two exceptions, or one exception, the Louisiana Heartbeat Ban, is still in effect simply because it is a trigger ban and it goes into effect should Roe v. Wade be overturned, or should I say when it is overturned. The Tennessee heartbeat bill was struck down within an hour of its passage. None of these bans or regulations have withstood federal court challenges. None have saved any lives from abortion. Furthermore, courts have forced those states to reimburse the abortion industry's attorney fees, costing taxpayers millions of dollars. Rather than protecting innocent unborn lives, these pre-viability bans have effectively become a meal ticket for the abortion industry. It is not possible to ignore the state and federal courts, including the Supreme Court. We are a nation of laws based on the Constitution, which the judiciary has a responsibility of interpreting. Texas can no sooner ignore the Supreme Court on abortion today than other states could ignore the federal court mandated dismantling of racial segregation laws in the last century. The questions for you all today are, what should we learn from the recent June Medical Services ruling? Should we continue advocating for immediate pre-viability abortion bans, knowing the federal courts will prevent enforcement and force taxpayers to pay huge attorney's fees to abortion industry plaintiffs? Do we need more predictable failures with severe costs? Can we move platform ideas that encourage ignoring our courts? Texas Alliance for Life has been lobbying, as I said, for pro-life laws in the Capitol for 32 years. We believe we should enact a longer-term strategy and focus our efforts on passing an abortion ban that goes into effect when the Supreme Court has more justices willing to take a fresh look at Roe v. Wade. 10 states have adopted this more strategic approach, passing what is called a trigger ban on abortion. This law provides complete protection from abortion, beginning at fertilization, when and to the extent Roe is overturned. There is no way this law can be challenged in court, and it will go into effect and begin saving lives as soon as possible. The legislature considered the trigger ban last year. Unfortunately, it did not pass. This is not uncommon for a new concept in its first session. We asked the Republican Party of Texas, and we will ask the Texas legislature this approach as a legislative priority when it convenes in January.
Does the committee have any questions?
Yes, sorry, just one question. J.R. Haas, SD7. So you said you're you're in favor of a longer-term strategy. So, and you said that Roe v. Wade was unconstitutional and atrocity, I'm sure. So, I mean, so is the last 47 years wasn't a long enough term? How many more years do you think we should take?
We have seen great success with the incremental approach that we've taken over the 32 years that we have been an organization, and we have seen numerous lives saved. We believe that we need to save the lives that we can under the precedent that's currently set, knowing that we cannot ignore the Supreme Court. So we'll work within those realms with the goal of putting something in the books that will overturn abortion rights in Texas when the power returns to the states, because that is what happens when Roe v. Wade is overturned. It's not automatically banned in the country. The states then have the power to decide. If we have a trigger ban on the books at that time, it's decided and it's done. And that is our goal.
Sorry, one last question. So are you aware that, so the claim that we're saving lives, are you aware that statistics are showing that not only in states where there have been limiting abortion laws, but also in highly pro-choice states, the rate at which abortions are happening are actually dropping drastically. So what effect is the current pro-life strategy, law having? I think the data indicated that. Go ahead. No. I'm actually asking her. I'm not debating. I'm asking about the claim that we're saving more lives. So are you aware that the data doesn't support that, or at least it
Just to make sure I'm understanding your question.
Yeah.
Are you asking me for the states that are seeing a decrease in numbers who don't have these laws, if then we can say that through our incremental approach, we've seen our numbers go down and it's due to that?
I think I can phrase it more concise. I apologize. So why are we seeing the same drops in states that don't have ending abortion laws as ones that are actually getting rid of abortion laws altogether?
The information that I've been going off of is for the state of Texas specifically, which is where I'm a delegate of. And the numbers that we got are from Health and Human Services, who have a lot of data that we can look at, that they do correlate to years. And we know certain bills passed in certain years, certain things became law. We can look at ITOP and see that abortion in minors have gone down. We can see the various things. So for Texas, I can tell you, yes, the incremental approach has worked. As to other states, because I'm not a lobbyist on the nationwide level, I haven't looked at all of that information. And so I don't necessarily feel equipped to answer a question to something that doesn't necessarily fall under our state specifically. But I would be happy to look into that and get back to you.
Mr. Chair, recognizes Marion Knowlton.
Thank you, Vice Chairman. Marion Knowlton, SD 19. It appears that this proposed legislation hinges on a couple of a phrase here, into effect when and to the extent that. What time frame are you anticipating for that phrase?
Don't you wish we all had the answer to that? That would be the golden ticket to so many things that we want to see done. I don't have that. I don't have a glass ball. I can't read the future. I know there's a couple things on the table. I saw, gosh, poor Ruth Bader Ginsburg is in the hospital right now. I do pray for her soul, but there's a lot of moving parts and pieces before that can happen, and I can't predict the future.
Including some of the current justices, I believe.
We do all share that.
Mr. Sheehan, did you have a question?
I'll wait till question is done.
Okay. Mr. Shelby, I believe, were you wanting to ask a question? Who was next? Somebody was trying to ask a question.
Oh, I was attempting to call a point of order.
Oh.
That's already doubled.
Does anybody else have any questions?
I just want to say thank you for your time and for doing what you guys do. I'm impressed. It's my first convention, and y'all are amazing. Thank you.
Thank you.
Mr. Chair, would it be appropriate to make a request of the committee real quick, 30 seconds?
Sure.
We have 18 minutes left and 6 speakers that have signed up. If it would be possible for us to keep our questions to clarifying the intent of the issue being raised rather than
kind of this further back and forth that we've seen. That way we can get through everybody before the time expires. I know the folks who've traveled here probably really appreciate that, so friendly request rather than any kind of motion. But
Appreciate that. Ready to proceed?
Sure. I'm a little confused by the gentleman's comment, though. Did y'all pass another rule that said we had to stop at 7 o'clock?
That's what the schedule said, so.
Well, it's a fairly flexible schedule.
Give or take 4
How
hours.
for information, how many do we have remaining at this point?
I have Senator Bob Hall listed on here again. I'm not sure if he's a speaker or
I think
not.
that's from previous, yeah.
Okay, then we have 5.
5. I would really hate to shut it off and only allow 2 or 3 not to testify. My intent was to take a break around, I think it would work out around 7:30, and then maybe some of the election returns would be coming in. And we have a little more discussion. And basically, when we get to the end of these next 5, that would be the end of delegate testimony tonight, even if that runs a little over 7 o'clock.
Mr. Chair, would you like a motion to clarify that we will accept the 5 that are on here and then?
I don't think we need it. I don't think we need it.
Okay.
Okay.
Ready to proceed?
Yep.
Thank you. The committee calls Mr. Wojciak. WWJCI, I think.
My name is Zbigniew Wojcik. I am a delegate from SD 25. I am a legal immigrant from the Soviet bloc, from Poland. I came in 1986. I passed a lot of information to US intelligence about the communist terror over there, and also information how to collapse the Soviet bloc. Because of my experience with the communism, so the issue is right now in Soviet bloc, the political opponents were very frequently charged with mental diseases. So there are plenty of communist activities. The issue is definitely to find the way to set up the legislation. The problem is that we don't have it yet, and it simply means that the communist terror is extremely sophisticated. It's not just somebody, does something wrong. It is highly organized. So we know that it's organized on the very top government level. And this is the Democratic Party responsible for that. So my book presents quite a lot of details about that terror that is coming to America. So maybe we have some questions.
Okay. Does anybody have some questions? Yes.
Janera Lewis, SD 27. Did you write a resolution?
Yes, I wrote 3 resolutions. So I already testified in the committees.
Okay.
And well, I don't know what the decisions will be, but I have the resolution, and I wrote also the planks, the propositions.
Okay, and also, sir, what's the name of your book?
The title of the book is, I have that in the leaflet, so I will definitely share that information with everybody. I have a few leaflets left. The title of the book is Slaying the Soviet Beast, and my name is Zbigniew Wojcik, W-O-J-C-I-K. You can find it on the internet, it's available. It describes the situation of a family, with my family, after I practically escaped from Poland during the communist time. It was hard. My family was kept hostage. The passports were revoked. And finally, at that time, Vice President Bush had direct intervention with the Polish government, communist Polish government, to let my family come to the United States. There is very nice story for it.
Thank you very much.
Mr. Dion.
Thank you, Rich Dion, SD9. It was good talking with you this morning. Thank you for making your way around to the various committees, and thank you for bringing your story here. Thank you.
Yes, I think Americans need some opinions of people who are dissidents. And possibly one of, maybe from Texas even, at least the person who was able to write and to speak. I'm a politically active person. So I definitely would like to present the problem.
Gentlelady's recognized.
Julie Pickering, SD11. Again, Mr. Wiechek, I would like to just say thank you for your courage and your bravery. And welcome to America.
Yes.
Just many years later. And just thank you for joining the fight of freedom.
Yes. Yes. We really need to keep them, and we need to fight for it. We have to be active, not just only to talk, but actively do things.
Mr. Chair.
Yes, very quickly, Mark Ramsey. I also would thank you profusely for speaking out. I've got several friends that are refugees from various countries, Cuba notably, another Virginia Prodan, you may know her from Romania. They all have very, very, very similar stories. It's astounding how similar they are. But the question to you, without taking too much time to think about it, is what, of all these different things that they may be hitting us to destroy our culture, what are the one or maybe two that you think were the most damaging in your experience?
Like communist damages. It's just killing people who directly disagree, who are fighters. Because I was trying to cheat the communism. That was the only way, in my opinion. And the CIA liked that. But I have one. The problem is that if somebody is against and declares that officially, they know about that, they check you, and then they kill you this or the other way. It's a very famous case of Father Popiełuszko, who is about to fight, and he openly was against the communist rules. He was killed. And not just simply shot. He was tortured for, I believe, 2 days. For 2 days, imagine the torture in 2 days.
Thank you very much.
Gentlelady recognized.
Thank you, Mr. Chairman.
Just one more question. I'm sorry, just one more question. Julie Pickering, SD11, just to build on Chairman's question. Of the current events going on, and just quickly, of the current events that we currently see in society, what do you think is the biggest threat to us right now?
In America, well, what they attempt to do is to have the fighters. Hillary Clinton wrote a communist manifesto. She complains that there are not enough fighters. So what they do right now is to do the riots, LGBT, blah, 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 the race issue, but there is still not enough, it's not enough power, still. So right now the danger is that there is not enough information. The media are against really the freedom in America. So that is a danger. They should inform people that the communism is coming. When people know that the Democrats are in fact the communists, most likely they will stop supporting the communism, because otherwise it will be a problem.
Thank you, sir.
Any other questions? Thank you.
Really well.
The committee would call Jackie Schiefel. And the last lot on deck is Raphael Bayar, Jonathan Hall, and Lauren Lavender.
Already causing trouble. My apologies. Oh, gosh. Okay, I'm just gonna hold this. Jackie Schlegel, I am a delegate from SD9, speaking on medical freedom. Thank you for allowing me to come up here today and give my second impromptu plea to you. The first was not planned and neither was this one, which I'm a little embarrassed about. And I need to apologize for, because the truth is, the issue I am most passionate about, I nearly did not come and present to you. And this is a horrible, horrible cycle we have gotten ourselves into. But many of you, I feel rather jaded by legislative priorities. It was great to be in my committee yesterday, to be in an echo chamber of people who believe in the fundamental freedoms and liberties that we are all here discussing. It's been amazing to talk to all of the different activists who inspire us to keep fighting the fight. But when it came to legislative priorities, the truth was, my attitude was, who cares? Legislators not gonna listen. It's not popular. It doesn't fit into their narrative. And I was so deeply convicted about this earlier that I thought it doesn't matter if they listen. We are obligated to stand up for what we believe in and fight back. It took me back to 2015 when I launched the organization Texans for Vaccine Choice. You want to be unpopular in this state, talk about vaccines on the record. But legislation had been filed to take away my right to choose for my children whether I wanted to vaccinate them or not. The irony is, I had already vaccinated, and it was too late. This precious child suffered a severe vaccine injury at the age of 4 months. She's 19 years old. She's permanently disabled and she'll live with me the rest of her life. It's an incredible blessing and yet an overwhelming burden to care for a disabled child. But she's not alone. Thousands and thousands. My phone does not stop. Every day my phone rings with families whose children have been vaccine injured. But we can't talk about it because it doesn't fit the narrative. Back in 2015, I showed up at the Capitol, and I remember I didn't know what I was doing, but I just needed to do something. And then I saw these legislators sitting in a committee hearing, and I thought, my God, I'm too late. They're already voting to take my rights away. I gotta do something about this. And I had that same moment earlier today, where I'm sitting here and you know what, I just decided it doesn't matter. We might make medical freedom a priority and nobody's gonna listen. But here is my plea to you, okay? I recently wrote the Republican Party Health Check blog. The left has hijacked the messaging of science and health. They have silenced us and sent us into the corner like children, cowering because we are afraid to be called science deniers, flat earthers, whatever the name they want to come up. And I heard a gentleman earlier say, you know, the left is doing this. Yes, they are. But what's worse than the left hijacking healthcare is the fact that we allow them to control the narrative. We allow them to dictate what we do and do not do regarding our healthcare choices. Healthcare is personal responsibility. It is not the role of the government. Texans for Vaccine Choice is fighting on the front lines of protecting and advancing informed consent, medical privacy, and vaccine from those components.
You should not either. We have a governor right now who is mandating masks for you to go grocery shopping. What are you gonna do when he mandates a vaccine? Are we gonna stand and cower in the corner, afraid to fight back? My families are at home with their special needs children, vaccine injured, who can't even take them to the grocery store right now, in fear they're gonna have the police called on them. That's what I'm here today with. And I ask you to add this and make informed consent, medical privacy, and vaccine choice a priority. Thank you.
Paulette Carson, SD. I have a question for you specifically, but I'd like to preface a couple of comments. I have a special needs son who's 21. He was premature choice in the vaccine damage, and et cetera, until I got educated very quickly. He had the first go round. He has now suffered some consequences because of that. In 2012, I met with my representative, James White, at that. And he encouraged me to start an organization called Voices for Special Needs East Texas, which we did. And I encountered a lot of families, and my question to you is this. And you also encountered the fact of parents not even having a clue. Families that are special needs families, anyone. But there is a thing called just medical exemptions, but conscientious. And school districts buffalo you, don't they? They buffalo parents. Parents don't know about that. And so they're told, you can't put your child in school, you can't put your child in daycare, you can't do this, you can't do that. And have you run into that yourself?
Oh, absolutely. And it is not just the school entrance vaccines, it is just choice in general. I mean, that is absolutely, the narrative is do not question, do not ask. Anything other than that is not going to be tolerated or accepted. So,
Mr. Chair, Mr. Hoffman, SD7. First of all, I'm so grieved to hear what you've endured. I can only imagine as a parent having, given my child 4 children, something that would harm them like that. But praise God, you still have a life, right? But then, can you just educate me, because I don't know, how many children every year are vaccine injured, as you put it?
that's a good question because you don't know they can't find the answer they're not looking for. Sometimes I'm here in a place like this and I talk to a generation that says, what about polio? We're not talking about polio. We're about 74. What are we up to now? I do this for a living. Doses of vaccines in childhood, and 2 points here. They've never tested this schedule in combination. That has never happened. They don't test what happens when you give 9 vaccines in one day. My daughter had 9 vaccines in one day at the age of 4 months. We left the doctor's office and started having seizures. They test them individually. Maybe she would have had 1 and not the other 8, we wouldn't have had that reaction. But you can't find what you're not looking for. But I can after week, families would come to the Capitol and I would see the difference between happy, healthy, homeschool families, let's just be honest, mom, dad, and there's these articulate, wonderful, beautiful, well-spoken toddlers, well-behaved. And then you have like my kids and the other ones running around banging their heads into a wall, screaming bloody murder. They're not speaking. We have 1 in 6 children that's developmentally disabled, and yet we've never tested this. I don't think that shy away from this point. Our generation is absolutely dependent, and I believe Texas can lead the charge in fighting for our medical freedoms.
that one of them's about my age, and one is in her early 30s. So it happens, but they wouldn't diagnose it that way.
Yeah.
They wouldn't say that's what caused it.
And you can't talk about it either, because that's going against the narrative, and we have to stop that. If this is about protecting individuals and putting the... Sorry.
Limited support questions.
Yeah, just, and now I forgot what my question was, so let me just thank you for coming. You're an amazing spokesman of the way you deliver the message. So
Thank you.
Any other questions? Thank you so much.
Thank you.
Committee will call Raphael there. Raphael? Please state your SD delegate status.
Raphael Behar, delegate for Senate District 19. Mr. Chairman, members of the committee, first of all, I want to thank you all for your service. I know exactly what you're all going through. Hats off to you. I know it takes quite a lot just to sit down and just to listen, and I appreciate that. I'm here, I'm also the Director of Outreach for Texas Public Policy Foundation. I'm sure that many of you have heard of I'm not here to speak on just one issue. My goal is to be the shortest testimony you have today. I just want to list the 10 items that we have on our conservative agenda. You've all already received, or should have received, emails providing detailed information on all of these planks. I just want to mention what they are very quickly, and then I'll be done. So the first one is to basically putting an end to taxpayer-funded lobbying, something that local governments to submit a third-party independent audit for their budget and operations to identify waste, fraud, and abuse. Local municipalities are just going crazy with their budgets and operations, and they're blowing their budget at the expense of the taxpayers. Also, support community-based foster care reform. The next item is a better balance constitutionally protected rights and government power in times of emergency. This is all the government overreach that we've been seeing during the time of the virus. Also, to uphold the importance and freedom of employers and employees to negotiate their contract without interference of local government. And then we have 2 items for education. Number 1 is to prioritize instruction in the founding documents of civic education in Texas, specifically the Declaration of Independence and the U.S. and Texas Constitutions, the Federalist Papers, number 1051, and the first Lincoln-Douglas debates. There's just misinformation and just not being taught in schools, and we want to make sure that that's included. Also, putting an end to the artificial cap on providers of virtual education in the state and other limitations on Texas students' ability to freely access digital courses and through virtual school networks. Another item that was passed in the last convention was phase out and eliminate the M&O portion of property taxes. And then the last one would be to treat mail-in ballots with the same legal protections as ballots cast at the polling locations. So as I said, you should have already received emails with this information, and one of our policy experts speaking for like about 5 or 10 minutes on each one at length, so you can review that at your leisure. Thank you.
The committee calls Dr. Hall. Please state your SD and delegate status and issue you need to speak on.
I wanted to speak about ending taxpayer-funded lobbying. I do want to say real quick, I think pro-life and abolishing abortion should be number 1, but I think another priority needs to be ending taxpayer-funded lobbying. So I'll go into that real quick. I've spoken on taxpayer-funded lobbying from both sides. So my family and I have been volunteer advocates in the legislature for several sessions now, and we've been up against a lot of the things. So, and I'm not an expert necessarily on that, but this would just be talking about your taxpayer funds being used for lobby purposes. I don't think it would touch any of their other functions.
Thank you. Any other questions?
Just a comment. I just want you to know that I brought up the insurance, not trying to show you their value and why we like them so much. It's the only reason we're with them. They send us magazines in the mail, and I can't opt out of them, even though you opt out, we still come. My box is polluted with their stuff, and it's all extremely progressive. Now, some of it is useful, but if I can't even pull through it anymore, I'm not interested in looking at their stuff. But anyway, thank you.
Another question? Any other question? Thank you so much.
Thank you.
Guess what? Last but not least, the committee calls Lauren Lavender.
69. What I would like to see from the RPT this time around for legislative priorities is that it takes a very strong stand. I want to see you be bold and intense. I want you to not be afraid to express opinions that the world might see as extreme. I want you to go gung-ho and burn it down. The reason that I say this is because there's something called the and this is what people see as normal in the world. And there are things that we want to see changed, and we need to hammer those hard. You say exactly what you want, you hit it, you hit it, you hit it, and eventually the world is pretty normal. Hey, that doesn't seem so odd. With that being said, I have 3 main areas that I would like to see as legislative priorities. So life, liberty, and property. And that's actually 4 legislative priorities that I had.
Point of order.
Yes.
I'd like to make them,
I thought that I was allowed to.
is it appropriate to make a motion? Or is the
Comments, one comment.
Oh, I'm sorry, I was under the impression that it was like 5 minutes for the first one.
Since this is the last speaker, I'll overpower to proceed.
Okay, I'm sorry, I truly misunderstood. I missed that part and I have gotten filled in apparently erroneously. But okay, so there are 4 items I'd like to see the RPT hammer. The first one is life. I want us to have an abolished abortion, not an hey, let's go for something that's lesser. No, we hit it hard. Everybody says we want to abolish abortion. We go into the legislature, and if they have something that's a fetal heartbeat bill, we don't testify for, we don't testify against, we testify on, and we say, hey, that's great, but I want this. We want this. We as a party do not want to see anyone murdering small children.
Right.
Like, we just don't like that. So, is liberty. And for this, I'd like to see us have a priority for medical freedom so that we can choose what goes in to our bodies and what does not go into our bodies, and liberty and protect our bodies. The 4th one is I'd like to see property tax abolished. So property is the 4th one, the 4th priority I'd like to see. A new, but yes, it is expensive. I have fought my property taxes every year that I could. I have taken in a binder full to them to protest my property taxes, and it has done very little good. They consider it merciful, and they actually told us it was merciful, that they were going to not charge us the crazy, gave us a little bit off. So those are my 4. My main one, of course, is first one, life. I really think we need to be hammering that home. The rest of these are also very important, and we need to go in there. We need to say abolish property taxes. We need to say abolish abortion. We need to say I want straight up constitutional carry. I don't want any of those gun control laws. And like I said, you go into the legislature, you've got for and against, and you testify on, and you tell them, that's great, but I want something more. Thank you.
on Sassenfeld SB 29, what would you recommend?
Any other questions?
How do
Text section stuff.
Mr. Reed? No questions, I just want to say that's a great way to sum up the day. Good job.
Mr. Vice Chairman,
Yes.
being a real estate broker, I have heard an appraiser say that you squeeze them till they squeal. And that's what happened with your property taxes. So when you squeal, they stop.
I think he means stop. I'll turn it over to the chair.
Okay, we stand temporarily adjourned until 8 o'clock. We'll take a short break here, and there may be some lectures some of y'all might be interested in. And one thing to try to, just to let you be aware of, the reason I had to leave the room earlier was the Rules Committee was considering not allowing us going to 15 and letting the delegates knock it back to 8. And you might, if you know your rules are over there, encourage them to proceed on the 15 divided by 2 equals 8 plan is kind of how I phrased it over there. I think it was fairly well received, but the Rules Committee is the Rules Committee. It's up to them ultimately. We've changed the rules to the time that ends up being back to the way it was 2 years ago. That's going to create a lot of extra work and I'm sure gnashing of teeth over in this committee. So I just want you to be aware of that. Let's meet back here at 8 o'clock. We'll start knocking the list down at that point, rewording, all those kinds of things. Tentatively tomorrow, and I'll send this out in another email, if I can figure out how to number them right, we'll meet at 8 o'clock, committee of the whole, of testimony at 9 in the morning and 10 a.m. for some online, at about 11, and you know, I can't promise we'll get out of here at 12, but if we get things pretty well worded and narrowed down tonight, and first thing in the morning, latest, and not early 12, we were talking on Monday. Yeah, somebody says in the morning. Okay, so back at 8 o'clock, please. Yes.
How late do you think we'll go?
Today?
It's true. You do know how long it took us to pass the rules, right?
Your committee, yes, I do. Not sure, I'm guessing about tonight.
Back by 8.
Yeah.
Mr. Chairman, quick question over here, ST3.
I
Commented about the Rules Committee and their desire to possibly cut it back to 8.
No, actually, they were operating, apparently not knowing that the SREC had changed the rule. Message to them, they were actually going to knock it all the way back to 5.
Okay, then my question is, did they give you a justification of why they wanted to do that, or they flatly?
To understand, and also they did not understand all that. And I mean, I would be optimistic they're gonna go with us on this, but you might encourage them.
Yes, sir.
If you know your counterpart on the Rules Committee.